Hang on. Are you saying the issue is with the notice? I've checked it is correct. I've checked the grounds. Yes. The notice may be correct, but the issue appears to be procedural. And that could affect the outcome of the possession proceedings. Buried inside the renters' rights changes is a provision many landlords may barely have heard about.
It is not the abolition of Section 21. It is not rent bidding. And it is not periodic tenancies. It is Section 16D of the Housing Act, 1988. Good landlords have nothing to worry about. Politicians have repeated the phrase throughout the renters' rights debate. Ground 16D may complicate that picture. A technical-sounding provision that leading property barrister Harry Angelides believes could later become one of the most important parts of the entire reform package. Because what looks like administration at the start of a tenancy could later determine whether possession succeeds or fails altogether. And according to Angelides, that is exactly why the private rented sector is entering a completely different legal era. The margin for error has gone. That is his warning. Not because landlords never faced paperwork requirements before. They did. But because the entire structure underneath possession has now changed. For years, many landlords operated with one underlying reassurance. If problems escalated, if arrears increased, if the tenancy broke down, there was usually still a route back to possession through Section 21. That safety net has now disappeared. Assured short-hold tenancies have been abolished. Fixed-term tenancies have been abolished. And Section 21 evictions have been abolished. Every private tenancy in England is now periodic and open-ended. And according to Angelides, what replaces the old system is something far more rigid, a system of statutory control and procedural discipline, which means possession is no longer something landlords recover simply through notice and time. It is a remedy that must be justified, prepared, and proved, he says. Every stage now matters. And perhaps nowhere illustrates that more clearly than Section 16D, because hidden within the legislation is a requirement for landlords to provide written statements of terms and prescribed information at the very start of every tenancy. At first glance, it sounds administrative, routine, the kind of paperwork many landlords may barely think about, but the consequences can emerge much later. Because whether certain possession grounds are properly included at the outset may affect whether landlords can rely on them during possession proceedings later on. In other words, the mistake may happen on day one, but the consequences may not appear until months or even years later in court. And under the new system, there is no Section 21 fallback if something has gone wrong. There was always a myth about landlord and tenant law in England, Angelides says. The myth was that provided you had a tenancy agreement and a Section 21 notice, possession was ultimately within your control. Those practicing in the field knew otherwise. What the Act has done is remove even the illusion of that control. Landlords must now prove a statutory ground under the expanded Section 8 framework, and in some cases, wait up to 4 months before proceedings can even begin. Which means preparation now matters more than ever. Compliance matters. Procedure matters. And what happens at the beginning of the tenancy may later shape the outcome of possession itself. There is also another major requirement approaching. Landlords with existing tenants must provide a statutory information sheet explaining the renters' rights changes by the 31st of May 2026. Failure to do so could lead to financial penalties of up to £7,000. And the wider reforms continue to reshape the sector. Rent increases are limited to once per year. Tenants can challenge increases through a formal hearing process. Rental bidding wars are being banned. Blanket bans on benefit claimants are unlawful. Blanket bans on families with children are unlawful. And landlords refusing pets must now provide proper justification. Taken together, Angelides says the direction is unmistakable. The landlord is no longer operating within a largely contractual framework supplemented by statutory rules. They are operating within a statutory system that governs the contract from start to finish. Errors at the outset are no longer irritants, they are structural weaknesses. And perhaps that explains why many landlords are now reassessing the future of the sector itself. Because this is no longer simply about serving notices correctly. It is about navigating an increasingly technical legal framework where compliance, preparation, and procedural accuracy now shape the entire tenancy from beginning to end. For a generation, the private rented sector often ran on routine, experience, custom, and the quiet reassurance that Section 21 remained there in the background. That era is over, Angelides says. What replaces it is a system with no shortcuts, no safety net, and no tolerance for the kind of errors that once went unpunished. And his conclusion is blunt. Landlords who adapt will continue to operate successfully. Those who do not will find that the difficulty of obtaining possession has not merely increased, it has become determinative. Because under the new system, the margin for error has gone. So you're saying the notice isn't valid? No, the notice may be valid. The problem is the missing written statement of terms and prescribed information.